The law is the law. It's a phrase which has gained prominence in Ghana, and you've probably heard it being thrown around on radio, social media, in courtrooms, and even on the streets. It's simple and almost dismissive, but beneath those four words lies a very sobering truth. The law in all its wisdom can be cold, rigid, and unyielding. And this is a case where a man came face to face with the law's inflexibility. The man won the people's vote, fair and square. They chose him to speak for them in parliament. But then came a question: was he even supposed to be on the ballot in the first place? This is the story of James QUAYSON, the Assin North MP who was removed by the Supreme Court, not because he cheated, not because he lied, but because the law is the law. It's December 7th, 2020, election day in Ghana, and James QUAYSON is on top of the world. The votes have been counted, the results are in, and he's officially the Member of Parliament elect for Assin North. Fast forward a few weeks, he's sworn in to sit in those hallowed halls of Parliament, making decisions that affect millions of people in Ghana. But his story took a twist. Enter Mr. NIMFAH, a man with a very specific mission and some very damaging information. Something explosive had been discovered about the newly elected MP, James QUAYSON, the people's choice. He was not just a Ghanaian, he was also Canadian. He was a dual citizen. Ghana's Constitution, specifically Article 94(2)(a), indicates that you cannot be an MP if you owe allegiance to a country other than Ghana. But here's where the story gets absolutely delicious with irony. Mr. NIMFAH's lawyers didn't just wake up one morning and decide to challenge QUAYSON on a whim. They had precedent, and not just any precedent. They had a Supreme Court decision that was practically gift-wrapped for the argument. The case was a Republic versus High Court Accra, ex-party Senator Rawlings. And here's the kicker that makes the whole thing feels like a soap opera. The lawyers who originally made the winning argument in the Senator case were from the same political party that was now trying to defend QUAYSON, the NDC. Senator Rawlings, daughter of former President Jerry John Rawlings of blessed memory, had won the 2016 primaries for the Koliklote constituency, but then someone had discovered a tiny problem. She wasn't registered to vote. Now, being a registered voter is literally the most basic requirement for becoming an MP. The case went all the way to Supreme Court, and the justices made a decision that would come back to haunt QUAYSON's defense team. The Supreme Court ruled in no uncertain terms that a person seeking to become an MP must meet all constitutional requirements at the exact moment they file their nomination papers. Not during the primaries, not before the election, not after winning. At the precise moment those nomination forms hit the Electoral Commission's desk. The NDC's lawyers, QUAYSON's party, were the ones who had made this argument so convincingly that it had become binding law and binding precedent. Fast forward to 2020, and those exact arguments were being used against their own candidate. So Mr. NIMFAH, armed with this precedent, marched into court with a straightforward argument that between October 5 and October 9, 2020, when James QUAYSON filed his nomination papers, he was carrying both Ghanaian and Canadian passports. It was NIMFAH's view that Mr. QUAYSON therefore owed allegiance to both those countries. The Electoral Commission knew about this. People had raised concerns and questions had been asked, but QUAYSON was allowed to contest anyway because he claimed that he was in the process of renouncing his Canadian citizenship. NIMFAH dove deep into the philosophical and legal concept of allegiance itself. He cited the 2012 case of Assin versus the Attorney General. He brought in Australian precedent and made an argument that was simple yet very compelling, that you cannot be a citizen of a country without owing that country allegiance. Allegiance and citizenship aren't separate concepts that you can pick and choose between. They are two sides of the same coin. Now, James QUAYSON wasn't going to go down without a fight, and his defense was very, very rigid and sophisticated. His lawyers, of course, could not deny the dual citizenship. The evidence there was overwhelming. Instead, they went for a more nuanced approach based on three pillars. First, they argued that Mr. QUAYSON had started renunciation processes way back in 2019, a full year before filing his nomination. Essentially, they were saying that the actions taken were not some last-minute scramble to fix a problem. It was planned, and by November 2020, way before the December election, he had a certificate of renunciation in hand. The Canadian government had officially released him from his citizenship obligations. Second, and this is where they got really clever, they argued that the citizenship and allegiance were actually distinct concepts under Ghanaian constitutional law. Looking at Article 94, citizenship is mentioned as a separate qualification requirement. If indeed the constitution treats them as separate and different things, then maybe you can be a citizen of another country without necessarily owing that country your allegiance, especially if you are actively working to sever those ties. Third, they made a timing argument. The constitutional bar against owing allegiance to another country, they argued, only kicks in when you actually take the oath as a member of parliament. The law on challenging public elections, PNDC Law 284, talks about challenging someone's election if they were disqualified at the time of their election, not at the time of nomination. It was a subtle but crucial distinction. QUAYSON's team also threw up some procedural challenges that were to be expected. They argued that the whole Supreme Court case was really just an election petition dressed up in constitutional clothing, and election petitions belonged in the High Court, not the Supreme Court. Pointed out that there was already a case dealt with in Cape Coast High Court about the same issues. So this Supreme Court action was just forum shop. The Electoral Commission, which should have been a key player in this dispute, basically decided to sit on the sidelines. They were listed as second defendants, but they chose not to defend themselves. The Attorney General, however, was ready for war. They started with the Senator President, hammering home the point that constitutional eligibility requirements became active the moment you filed nomination forms. They pulled out the Canadian Citizenship Act and stated that according to Canadian law, you only cease to be a Canadian citizen on the specific day that your renunciation certificate is issued by the Canadian authorities, not when you apply. This created a significant timeline problem for QUAYSON that was not possible to solve. He filed his nomination in October 2020, but he didn't receive his renunciation certificate until November 2020. There was a gap, a window of time during the crucial nomination period when he was unambiguously, legally, officially a dual citizen. The AG then delivered a very emotionally charged argument. They talked about the oath that QUAYSON would have taken when he became a Canadian citizen years earlier. That oath includes specific language requiring new citizens to bear allegiance to Her Majesty Queen Elizabeth II, the Queen of Canada. How? The AG asked, can someone who has sworn true allegiance to Canada simultaneously claim to owe no allegiance to Canada when seeking to represent Ghana in Parliament? It was not just legally contradictory, it was logically impossible. The Attorney General argued that allegiance, properly understood, means exclusive holding of Ghanaian citizenship. You can't serve two masters. You can't split your loyalty between two countries and expect one to trust you completely. Holding multiple passports is objective, verifiable evidence of allegiance to multiple countries. Any attempt to pass allegiance subjectively, to let people claim that they don't really feel allegiant to countries they are citizens of, would be legally absurd and practically unworkable. After these arguments, the vexed issues had to be resolved by the 7-man Supreme Court, led by Justice GYAKYE. The court carefully worked through 7 separate issues covering areas of jurisdiction, qualification requirements, the meaning of allegiance, procedural objections, as well as remedies. On jurisdiction, the court ruled decisively that they had every right to hear the case. The High Court case in Cape Coast was purely an election petition, a challenge to the specific results of a specific election. But the Supreme Court case was fundamentally different. It was about interpreting and enforcing Article 94 of the Constitution itself. These cases weren't competing cases about the same issue. They were different types of legal action arising and addressing different aspects of the same underlying problem. The Supreme Court noted that the facts were essentially identical to an earlier case, Sumaila Bilbo versus Adamu Dramani, where similar jurisdictional arguments were made and rejected. But the real meat of the decision came when the court addressed the central question: what does owe allegiance to a country other than Ghana actually mean in real life? The court went back to its earlier decision in Asari versus Attorney General, a case where Professor had challenged Ghana's restriction on dual citizens as discriminatory. In that case, the court had explored the deep connection between citizenship and allegiance, noting that the committee of experts who drafted Ghana's constitution had placed allegiance at the very heart of citizenship itself. The justices pointed out something that should have been obvious, but appeared controversial. High-profile positions like the IGP, ambassadors, and other important security roles were explicitly barred to hold dual citizens, precisely because Ghana demanded unquestionable allegiance from those people in those positions. If the nation won't trust dual citizens to be police chiefs, and whatnot. How could they possibly trust them to be lawmakers who shape national policy? The court also noted that Ghana's own Citizenship Act requires people to take an oath of allegiance to Ghana and no other country when sworn in. The entire legal framework is built on the assumption that citizenship and allegiance are inseparable concepts. When it came to QUAYSON's renunciation argument, the court was crystal clear. He pointed out that his November 2020 renunciation certificate was completely irrelevant to his constitutional eligibility because he didn't have it when he filed his nomination papers in October. Citizenship, they noted, is a question of law determined by individual states, not by individual intention or applications or good faith efforts. The certificate of renunciation was not just a nice to have piece of paper, it was absolutely material evidence of Canada's official decision to release QUAYSON from citizenship obligations. Without the certificate, any claims about renunciation were just unilateral declarations, like signing an affidavit. Legal and meaningful renunciation requires the other country to actually agree to let you go. The court's final interpretation of Article 94 was elegantly simple and clear. In plain English, they said that the constitutional provision meant that a person cannot be qualified to be an MP if he is a citizen of a country other than Ghana, period. No exceptions were made for good intentions, no allowances were made for pending applications. James QUAYSON, the court ruled, was not qualified to be a member of parliament when he filed his nomination papers in October 2020. His election was therefore unconstitutional. His swearing in was unlawful, and his entire tenure as an MP was null and void. The court ordered his name to be immediately expunged from the parliamentary records. And here is where this already incredible story took a very amazing turn. After all the legal drama, all the constitutional interpretation, public embarrassment, and public upheaval, after having his election declared void, James GYAKYE decided to run again in the by-election after this disqualification. And the people of Assin North, knowing everything that had happened, still voted for him. Again, he won the election decisively, returning to the exact same parliamentary seat he had been forced to vacate. This time, of course, he was fully qualified. No dual citizenship, no constitutional issues, no legal clouds hanging over his eligibility. The QUAYSON case split the nation. For some, it's a win-win situation for the rule of law, clear rules, strictly applied, and no room for shortcuts. But for others, it was legalism taking too far. QUAYSON had already applied to renounce his Canadian citizenship. He got the certificate before the election. He wasn't hiding anything. He had no real allegiance to Canada. Still, the court said the law is the law. The court disqualified him. The people re-elected him because in the end, while the law is supreme, in democracy, the people always have the last word. Follow Super Law GH Studios for more real stories, real cases, real people.